Hey, this Halloween, let's meet Lorna. But before we do that, a reminder to always put your best face forward every day with Salive Protective Day Cream or Protective Day Lotion, which will replenish hydration and protect your delicate facial skin from signs of premature aging caused by the sun. Now, back to Lorna. A day before the would-be Halloween celebration within the company premises, Lorna, a department secretary for 12 years at ETSI, sent an email to her colleagues inviting them to participate in the trick or treat with their kids and themselves sporting some Halloween costume, but without seeking the approval of ETSI management. Learning that her plan was actually disapproved by the company's senior vice president or SVP, she sent another email stating in part that the SVP was so unfair. He feels as if somebody's always trying to outsmart him and that he can have the office all to himself. She also said that those parents, quote, who like to bring their kids in Megamall there will be trick or treating at McDonald's Megamall Building A at 10 a.m., unquote. As a result of sending that second email, Lorna was dismissed due to improper conduct or acts of discourtesy or disrespect and making malicious statements concerning company officers. Does Lorna's second email containing malicious statements about the SVP constitute legal dismissal? Yes. The dismissal was for a just cause, i.e., due to serious misconduct under Article 282 of the Labor Code. Lorna was also not entitled to reinstatement or back wages. The court said that Lorna's second email was not merely an exercise of her right to freedom of expression about the SVP's decision, but they were directed against the SVP himself. In Philippines Today Incorporated versus NLRC, the court passed on the attitude or respect that an employee is expected to observe towards an employer. It held that a cordial, or at the very least, civil attitude, according due deference to one's superiors, is still observed, especially among high ranking management officers. The court takes judicial notice of the Filipino values of pakikisama and paggalang, which are not only prevalent among members of a family or community, but within organizations as well, including work sites. No matter how much the employee dislikes the employer professionally, and even if he is in a confrontational disposition, he cannot afford to be disrespectful and dare to talk with an unguarded tongue and or with a baleful pen. Since it has been a tradition of the company to celebrate occasions such as Christmas and Halloween, does this fact remove the SVP's prerogative to approve or disapprove plans to hold such occasions within the company premises? No. It is the prerogative of management to regulate, according to its discretion and judgment, all aspects of employment. This flows from the established rule that labor does not authorize the substitution of the judgment of the employer in the conduct of its business. Such management prerogative may be availed of without fear so long as it is exercised in good faith for the advancement of the employer's interest and not for the purpose of defeating or circumventing the rights of employees under special laws or valid agreement, and not exercised in a malicious, harsh, oppressive, vindictive, or wanton manner or out of malice or spite. Is Lorna's dismissal too harsh that it is comparable to the case of Samson versus NLRC, where the court held that the dismissal of the employee was too harsh, even if he uttered to another person that their general manager and at the same time president is BS, while gesturing a middle finger and warning that the forthcoming national conference of the company would be a very bloody one? No. First, in the Sampson case, the court found that the misconduct committed was not related with the employee's work, as the offensive remarks were verbally made during an informal Christmas gathering of the employees, an occasion where tongues are more often than not loosened by liquor or other alcoholic beverages, and it is to be expected that employees freely express their grievances and gripes against their employers. In this case, Lorna's conduct was related to her work. It reflects an unwillingness to comply with reasonable management directives. Second, in Samson, the employee was held to be merely expressing his dissatisfaction over a management decision. In this case, Lorna's offensive remarks were directed specifically against the SVP. Third, in Samson, the insulting words were uttered in the absence of the general manager and president. In Lorna's case, while she did not address her email message to the SVP, she circulated it knowing, or at least with reason to know, that it would reach him. Fourth, in Samson, the court found that the lack of urgency on the part of the respondent company in taking disciplinary action against the employee negates its charge that the latter's misbehavior constituted serious misconduct. In Lorna's case, the management acted 14 days after Lorna circulated the quoted email message. Should Lorna's 12 years of service be taken as a mitigating circumstance? No. The court has held that the longer the employee stays in the service of the company, the greater is his responsibility for knowledge and compliance with the norms of conduct and the code of discipline in the company. Was Lorna's due process right, however, violated when ETSI did not inform her of her right to be represented by a counsel during her conference with the SVP and her immediate supervisor? Yes, as this right is clearly provided in Article 277B of the Labor Code, to wit, the employer shall afford ample opportunity to the employee to be heard and to defend himself with the assistance of his representatives if he so desires. The court also explicitly made a pronouncement that ample opportunity connotes every kind of assistance to enable him to prepare adequately for his defense, including legal representation. Therefore, ETSI's protestations that the right to be informed of the right to counsel does not apply to investigations before administrative bodies, and that the law and jurisprudence merely give the employee the option to secure the presence of a counsel in a hearing or conference, must fall. The violation of Lorna's statutory due process right entitles her to an award of nominal damage fixed at 30K.